My name is Catherine Long, and today I'm here on behalf of the Vermont Law Chapter of the Federalist Society, and we are proud to introduce the debate on campaign finance disclosure. To moderate this debate, I would like to introduce Ross Knight, former news director at Vermont Public Radio.
Thank you. I think everybody has programs, so we'll probably dispense with formal introductions of the panelists. For all of their bona fides, you can look in the program. But as joining me here are Tara Malloy, who is the Senior Counsel for the Campaign Legal Center, and Bradley Smith, who is Chairman of the Center for Competitive Politics and Chair of the West Virginia University College of Law. So we want to do 5-minute introductions and then get into the basics. So let's set the stage for what we'd like to address today, which is the state of campaign finance disclosure law as it stands in the wake of the Citizens United case and, of course, the 2012 elections. So can each of you explain your view of how disclosure has changed since Citizens and in the wake of the most recent election? And has that been good or has that been bad? Tara?
Sure. Well, first, thanks for having me. I will try to, I'm sure we'll have a lively debate, and we'll try to keep all you guys awake. So how has campaign finance disclosure changed since the blockbuster Supreme Court decision in 2010, Citizens United versus FEC? Well, to reach for some sort of literary nicety, it's sort of the best of times and the worst of times for campaign finance disclosure. It's the best of times because the courts have affirmed and reaffirmed again the constitutionality of campaign finance disclosure, as well as its importance. And in fact, it's not really that well known, but Citizens United actually, as a decision, reaffirmed the constitutionality of a campaign finance law. So the actual statutes weren't in any way changed by Citizens United in the disclosure sphere. But it's also the worst of times, and that is partially because the disclosure laws haven't changed. It's both good and bad. The disclosure laws haven't changed, and they are not designed to take into account the flood of independent corporate and union spending that the Citizens United decision basically authorized. To just review, Citizens United struck down the very long-standing federal restrictions on corporate independent expenditures in federal elections. These were in place since 1947. Up until this point, corporations and unions had to use PACs, which were a very highly regulated political committee, in order to do any spending in elections. So the spending went from a sort of a moderate amount to a flood. In the last 2012 election, we saw over $1 billion in independent spending. That's sort of up 3- or 4-fold from the last pre-Citizens United election. And at the same time, it's, as I said, the worst of times because the law didn't really take into account that spending, or it wasn't designed to capture that spending for the purpose of disclosure. And so we really were left, practically speaking, with a great dearth of disclosure. Moreover, there has been sort of a shift in the politics and the, let's say, ideology of disclosure, where many groups and individuals that were supportive have now sort of changed their tune. But I'll first just go quickly to go a little more depth into the best of times. So Citizens United, or really, the constitutional jurisprudence on campaign finance disclosure hasn't really changed since a 2003 decision of the Supreme Court in McConnell. And in fact, the fundamental validity of the disclosure of money funding candidates, political parties, and independent electoral spending hasn't really been in dispute for 40 years, maybe even 80 years, depending on how far back you go. Citizens United essentially reaffirmed this status quo. As I said, and the campaign finance laws, that is the campaign finance disclosure laws, have been on the books for a very long time too. Really, the bare bones disclosure laws have been on the books since almost a century. They've, if anything, been expanded and refined over the decades, not shrunk. So in some ways, we're at sort of the zenith of campaign finance transparency. What's more, there's been long-standing and very broad public support for disclosure of money in politics. According to a New York poll in 2010, shortly after the Citizens United decision, 92% of Americans say it's important for campaigns to be required by law to disclose their donors and how their funds were used. And this was really across party lines. There was almost no distinction between Democrats and Republicans. So this is pretty overwhelming support. So, in some ways, it's almost that this is a debate that isn't a debate. It seems it's been constitutionally settled, and certainly settled in the court of public opinion for a very long time, that political disclosure is a good idea. I don't really want to cut off a debate before you even start the debate, however, and certainly if you look around, it doesn't seem like, quote unquote, my side is winning in terms of what you might get in terms of information when you think about a candidate or a ballot measure proposal. And also, I would say that although in broad brushstrokes, the courts have been very supportive, in the details, it's much more difficult to determine what's constitutional and what's beneficial in the realm of disclosure. And one sort of legal point that I'll just highlight, because it's sort of a threshold question, is that what do I mean when I've been using the term campaign finance disclosure? The court has sort of had unwavering support for campaign finance disclosure. That is the disclosure of spending by candidates, by political parties, and in some instances by independent spenders. It's been much more mixed when you talk about political disclosure, and by that I mean sort of issue advocacy is the term of art. That might mean a ballot measure, a ballot initiative, the spending for or against that. It might mean lobbying. It might mean issue advocacy when the spenders claim at least to be talking simply about a political issue and not a candidate. There, the courts have been much more mixed. That's not to say these laws are unconstitutional, but they certainly have had a much more mixed record. So really, I'm simply talking about campaign finance disclosure. And in terms of certain core disclosures, I'm not even sure my opponent would disagree about their constitutionality or even advisability. That is, how candidates disclosing who gives money to them, for instance. That would be a very core campaign finance disclosure. But again, defining the broader sphere of what might be political or what might be campaign finance has been more difficult. And I would just throw out two terms, which again, it's somewhat technical, but I just want to get them out there because this is what we're talking about. In the sphere of independent spending, that is what has been freed up by Citizens United, there have been two independent types of spending that have been deemed campaign related and therefore subject to disclosure. That is, if a group were to do these type of expenditures, they would have to disclose their donors, they'd have to disclose a lot of information about their spending. These groups of communications are express advocacy. That is when you say, I vote for or against a candidate, support, oppose, McCain, 2008, Obama, forever, whatever. That is express advocacy, and that has been regulated for a very long time, since the 70s. A more recent category that's been also deemed campaign related is called electioneering communications. This was the desire to sort of plug the gap of people getting around the express advocacy definition, which, as you can probably tell, is pretty narrow. Electioneering communication is a communication that runs shortly before an election, 30 days before a primary, 60 days before a general election, mentions a federal candidate, and is targeted to the relevant electorate. Also, we're talking only TV and radio ads. So this kind of captures all sort of candidate-specific advertising in a very, very narrow pre-election window. And these are two types of independent spending that the court has by and by declared can be subject to disclosure. And so this is what I'm talking about. Unfortunately, following Citizens United, and I will wrap it up, but I just want to say, practically speaking, what has fallen apart here are these two categories that used to be subject to disclosure. That is the express advocacy, independent spending, and the electioneering communications. And that is simply because of the nature of the statute and even more the actions of, here's another player, the Federal Election Commission. That is the agency head in charge of campaign finance regulation, which have so tightened the definitions of these types of speech that really only those groups who have donors that specifically earmark their money for election spending have to be disclosed. So if I were just to give $100,000 to Priorities USA, that is a nonprofit organization who has done spending in the election, and not say anything, I would not have to be disclosed. I could give 20 million. As long as I wasn't foolish or honest enough to say, please use my millions of dollars for an election ad that fall into the two legal categories, then I would not be disclosed. And this is why we saw this sort of flood of spending in 2012 and to some extent 2010 at the federal level of all these Americans for America, Americans for Prosperity, Priorities USA, Prosperous GPS, all these very vague patriotic names where we didn't really know who was funneling the money into it. And we didn't really know, where the money was coming from. So again, Citizens United was technically or theoretically a reaffirmation of a disclosure, but in practice led to this sort of confusing maze of very patriotic but otherwise shadowy groups influencing our elections.
Okay, I don't think we have too much concern about having a debate here. So, Brad, would you like to take on the kind of the broad question?
Sure. Well, I think one thing that I agree with Tara on is in certain ways there isn't a big debate. You know, it's often framed as, do you favor disclosure or are you opposed to disclosure? Well, I don't think that's quite a proper setting because almost everybody favors disclosure. It's very hard to find people who are opposed to all disclosure. Almost everybody favors some disclosure. And the question really then is, what is it that should be disclosed? Now, the Supreme Court, for example, has upheld disclosure laws repeatedly, but they have not upheld all disclosure laws. They have not upheld many of the disclosure laws that are now being offered in state legislatures. In fact, they have struck some of those down, both as a facial matter and in applied challenges to the law. So the question is, what is it that should be disclosed? What does the public have a right to know? And this is a cost-benefit analysis. Does the public have a right to know who gives money to the C3, the Center for Competitive Politics that I chair? Does it have a right to know who gives money to Vermont Public Radio? Does it have a right to know who gives money to the Brennan Center, which, by the way, does not disclose its donors, but works very hard to have political influence, right? I mean, they come to things like this. And the same could be said, by the way, about my group, Center for Competitive Politics. So what is it that needs to be disclosed? Now, let me do a little thought experiment with you here. This gets a little dated now. It's much more effective when I do this in 2008, you know. But imagine the late days of the Bush administration. They had introduced the Patriot 2 Act. They said the purpose of the Patriot 2 Act, or at least one purpose, is to make sure that our politics is not infiltrated by foreigners, terrorists. President Obama now has raised that possibility. He said it's a real possibility. So they said, so to make sure that doesn't happen, one of the provisions of the act is that Americans would be required to report their political activity to the U.S. government. And the U.S. government will keep that in a database. But it's worse because they'll actually make that database available to Halliburton and folks like that, to your employer, if you want, to medical companies, insurance companies, things like that, right? What would be the reaction? I think the reaction among many Americans would be, this is outrageous. What the heck is going on here? Okay, we have that law. It's called the Federal Election Campaign Act. And under that law, your political activity, at least certain forms of it, are reported to the federal government, which puts it in a database and makes it available to Halliburton and insurance companies and prospective employers and nosy neighbors and your enemies, including your employer and your address, and so on. That's what disclosure is. So there is a cost-benefit analysis that has to be undertaken. Now, the reality is we have more disclosure than ever. And as Tara pointed out, it was not changed in 2010 by Citizens United, although she's also correct that the change in the law makes the disclosure system work a bit differently. But we still operate in a system now in which we have more disclosure laws in American politics than at any time in our nation's history. And we say, well, there's been this flood of money coming in. Well, it's true that independent spending after Citizens United has gone up, and it's about $1 billion, which is what would that be, about 15% of the total amount spent on elections in independent spending. Doesn't seem that bad to me. In fact, it seems like maybe a good thing. I've never quite bought into the idea that campaigns should only be reserved for the candidates and independent citizens shouldn't have anything to say about them. But, okay, how much of that is actually undisclosed? Well, let's start with the proposition that all of it is disclosed at some level. You cannot see a political ad in this country that doesn't disclose who paid for it. So when we say we want to know more, what we're really saying is we want to know not just who's paying for it, but we want to know who gave money to the people who are paying for it. Now that might be a very important thing to know. But if we know that an ad was paid for by Crossroads GPS, we do know who paid for it. We may say, we want to know who gave money to Crossroads. But how secretive is it? We hear shadowy groups and so on, right? Shadowy, it just cracked me up in 2012, how often you'd read a press report and would say, one such shadowy group is Crossroads GPS, founded by former Republican Party Chairman Ed Gillespie and consultant Karl Rove in order to promote conservative and pro-Republican values. I'm like, well, if these guys are a shadowy group, they were doing a really crummy job of it, right? We know all about them. Okay, so we do get a lot just from that, and it's not hard to look these things up. But still, we might want to know who's giving them money. How much of a problem is that? Well, according to the Center for Responsive Politics, who was quoted earlier today in one of the panels, and is certainly no friend of what I would call the free speech position in this debate, it's a reform organization by and large, About $315 million, that was the figure put up on a screen behind me earlier, was non-disclosed in the sense that it was not itemized. We don't know who gave the money to the group that did the spending. Well, that sounds like a lot of money, $315 million. That's about 4% of what was spent in the 2012 campaign. Now, $315 million sounds like we got a major problem facing this country we got to deal with. 4% sounds like, maybe we can live with that. And we can live with it if we start thinking about what are the consequences of further disclosure and why might people not want to have more information disclosed. And as we're going to get to, I think, in the course of Ross's questions, we see that disclosure can have a downside, an invasion of privacy that I've hinted at. In certain cases, people have been targeted for harassment, for threats, bullying, and these things are costs. I think there's also, I'm going to suggest to you, some cost in our political civility. Remember, the Federalist Papers were published anonymously, and one reason they were published anonymously is because the authors wanted the people to focus on the issues involved and not to engage in ad hominem attacks on the people involved. And that's what typically happens now with disclosure. We just use it to make ad hominem attacks on the particular speaker. At least too often we do. So what I want to suggest, and I'm going to wrap it up here, is put a couple issues on the table. We want to think a little bit harder about disclosure. Is it really worth the benefit? And I'll ask one question. How many of you actually go to the FEC website and look up, so you can determine how to vote, who's given money to your candidate? Not very many. And this crowd, let me tell you, is going to be a lot more than your typical audience is going to be. Okay? I'll add just to close with a couple points. When Chuck Schumer introduced the Disclose Act in Congress to try and get more disclosure after Citizens United, he said quite openly and specifically, and this is a quote, the deterrent effect should not be underestimated. In other words, his goal was to deter political speech hostile to the Democratic Party. That's what he meant, and that's what he said. Okay? And I think we should recognize that that kind of cost is there when we get into this business. And I think, and I'll raise one final example that kind of runs on the other side. What we are jeopardizing here in this quest for this manic, disclosure of everything is, to me, a very hard-won constitutional right of privacy. And this right came out of a series of Supreme Court decisions in the 40s and in the 50s and in the 60s, many of them involving the civil rights movement, Bates versus Little Rock, NAACP versus Alabama, Button, a whole bunch of these cases, right? Talley versus California, to say that the state could not force people to disclose who their members were and who their donors were, because doing so would inhibit speech and could allow the government or people, other private individuals, to retaliate against these folks and silence that speech. We've actually made an exception to that rule already in the realm of political speech, oddly enough, the area that's supposed to be the most protected under the First Amendment. So let's do a good cost-benefit analysis. And I think when you really do that, you'll realize that a lot of the concern these days voiced about disclosure is really hype that's a cover for a desire, as Chuck Schumer said, to deter certain people from speaking.
Okay, so we want to make this a little bit different than a typical debate and encourage active participation. So if you have a question, feel free to raise your hand. Tara has a microphone, and we'll take your question as we go along. But let's get into that question of the cost-benefit analysis and dig a little more deeply into this. So, Tara, what practical effect would you argue there has been from disclosing donations to political campaigns over 40 years, 80 years, whatever term you want to use? Who has benefited?
Who has benefited? Well, I have benefited, you have benefited, we have benefited. I think it probably comes as no surprise that I would say that the public benefits from campaign finance disclosure, knowing who funds your candidate, who funds your political parties, who funds even those shadowy or not so shadowy groups that run express advocacy telling you how to vote in your elections. And I think the interests in disclosure were well articulated by a fairly old case, Buckley v. Vallejo, which was decided in 1976 and is kind of the grandfather of all campaign finance cases. And there the court identified two principal public interests in having campaign finance disclosure. One, an anti-corruption interest, and two, an informational interest. The anti-corruption interest is probably the one that people are most familiar with. The sunlight is the best disinfectant idea. The court said disclosure requirements deter actual corruption and avoid the appearance of corruption by exposing large contributions and expenditures to light publicity. A public armed with information about a candidate's most generous supporters is better able to detect any post-election special favors that may be given in return. And this is sort of the most basic reason why people think you need disclosure, because if you're even going to be able to connect the dots of corruption, you're going to have to know who gave the quid and who got the quo, etc. Right now, you can say, well, everyone knows who Crossroads is, but you don't know who's funding Crossroads. So if indeed they got a earmark or a tax break or an ambassadorship, how would you even know that that was a government favor? Well, you wouldn't. And Crossroads spent hundreds of millions of dollars, so there are people who gave very generously. I don't mean to in any way say that Crossroads is unique. There was a large spectrum of groups across both sides of the aisle that were spending in 2010 and 2012. So there's an anti-corruption interest. The even broader interest that has been invoked more often is this informational interest. And that's the idea that if you want a democracy, you need an electorate that knows sort of what they're doing. Buckley again said, disclosure provides the electorate with information as to where political campaign money comes from and how it is spent by the candidate in order to aid voters in evaluating those who seek federal office. The sources of a candidate's financial support also alert the voter to the interests which a candidate is most likely to be responsive and thus facilitate predictions of future performance in office. Translation is, if you know who brought you, you know who you're dancing with. And whether they're independent or direct donors, it's helpful to know in terms of evaluating a candidate's position, who is really supporting them, and what is a better, more credible measure of support for a candidate than giving money, putting skin in the game. And this is sort of the idea of the informational interest. And you might say, okay, well, this sounds nice in theory, but in practice, does the electorate really get informed? And Professor Smith brought up that, well, maybe people don't really check the FEC database. Well, that's never really how it's worked. We rely on nonprofit groups and the media in particular, and newspapers to sort of aggregate that information for us. Very few of us are going to weed through every single report by every single candidate. And by and by, they do a decent job. Another area where you get direct disclosure is when you actually have a disclaimer on an ad. Various social science studies have shown that you actually see on the ad that the NRA paid for it or an insurance company paid for it. You have a pretty good idea of how to assess the credibility of the ad or the bias of the speaker. And there's actually been considerable research in the area of ballot measures. That is when it's just a question presented to the voters, not a candidate, about how much information helps. There was a study on insurance-related ballot initiatives showing that the voters who knew nothing about initiative details but knew the insurance industry's preference or who they were funding, they voted just as well as people who knew everything about the insurance-related ballot measures. So that just simply knowing the positions of the key players or the key funders was almost enough to get you to a point of education or enlightenment there. And particularly the Ninth Circuit has picked up on this and has upheld a lot of ballot measure financing disclosure laws, where it's even sort of harder to pick out who's supporting and who's opposing, because there's not even often the Republican or Democratic label to go by. And the courts have said, since voters may not understand in detail the policy content of a particular measure, they often base their decisions to vote for or against the measure on cognitive clues, such as the names of individuals supporting or opposing a measure, as listed in a ballot pamphlet, or the identity of those who made contributions or expenditures for or against the measure. So this has really been sort of the almost maxim of the Ninth Circuit, that this is a way that voters basically figure out how a complicated bond measure is going to affect them. They look at who's financing it in terms of the advocacy. And not only is the problem that it's helpful to know, say, what the insurance industry wants to do, or what Greenpeace wants to do, but very, very often in all contexts, groups, I think you have to admit, deliberately cloak their identities and interests in very vague names, and sometimes even take on names that indicate the opposite of what their interests are. And one of the court cases in the Ninth Circuit gave a specific example of disclosure preventing the wolf from masquerading in sheep's clothing. This was Proposition 199, which was in the 90s. It was called the Mobile Home Fairness and Rental Assistance Act. And it was presented as a noble effort to create fairness and rental assistance for mobile home park residents. However, the real interests behind the measure were exposed by various newspaper editorials and through disclosure laws. And they explained that the initiative's real purpose was to eliminate the local rent control for mobile home parks and was supported almost entirely by 2 mobile home park owners. Despite the fact that the mobile home park owners outspent opponents basically 6-1, once that information was out there and people realized that fairness and rental assistance might have different meanings to different people, that measure was defeated despite the vast outspending on the side of the mobile homeowners. So that's just one of many, many examples of how often the names are just so very deceptive, or at least, just vague sometimes. And that the informational interest, I think, is not simply a grand constitutional theory, but a very practical benefit to you and me.
So let's look at this from the other side. Specifically, what damage would you argue has been done by disclosing the people and organizations that pay for political campaigns?
I'd go back to Buckley, where Tara started. Let's start there. Buckley v. Vallejo, for example, generally said that it upheld disclosure requirements, and it did. It upheld the disclosure requirements in the Federal Election Campaign Act. But it did that only after it substantially narrowed those requirements, as Tara explained, limiting it to express advocacy or to organizations that were political committees that were organized for the major purpose of electing candidates to office. So if you were the NAACP or you were any other group, you were Citizens to Clean the Connecticut River, or whatever it might be, you didn't have to register if you then as a political committee and disclose all of your donors if you engaged in some political advocacy. We also suggested, she cited a survey, and if I got that correct, she said the survey asked them whether campaigns should be required to disclose their donors. Campaigns are required to disclose their donors, so that's already the law, right? And this takes us back again to this point that I don't disagree with Tara that in certain cases, disclosure is a very valuable asset. And I certainly agree that many times it's a good shorthand voting cue for people who want to figure out how to vote and can't begin to understand issues, especially very complex ballot measures. But again, what I call for is some sense of measurement, which I think is being lost. Almost everything that she cited are things that we already have on the books. And the question really now is whether we're going to go further into disclosure. Nobody is really talking about rolling back disclosure in any significant way. Nobody is talking about requiring candidate campaigns to disclose. The question is whether we're going to go even further than we've already gone. Now, what are some of the problems? I mean, one that I haven't mentioned, but this is something I really noticed when I was serving at the Federal Election Commission, is that disclosure really harms grassroots groups. One of the best ways to silence these naggy little grassroots groups, whether they're Occupy or the Tea Party or almost anything else, is to hit them with campaign finance charges, right? Violations, and they violate it all the time. I mean, we're representing a group out in Colorado called Coalition for Secular Government. These are just people, they publish long, turgid policy papers, pro-choice policy papers on their website. The state of Colorado says, well, you've got to register and report as a political committee, you violated the law. We're representing a guy in Colorado on the other side of the spectrum, a guy named Corsi, who he started a blog, and he blogged under the name the Geauga Constitutional Council. He lived in Geauga County. And he was very critical, he was a Tea Party guy, and very critical of the local Republican establishment, So the local Republican establishment struck back. The chairman of the local Republican Party, who happened to be on the county elections board as well, filed a complaint against him with the Ohio Elections Commission. Says, we got to know who you are. You're not filing a disclosure report. You haven't registered as a political committee. You're a council. You're 2 or more people working together. We need to know. The public has a right to know. And this is done all the time with very, very low thresholds. Now, taking this further, one of the things I found and really noticed at the FEC was it's pretty easy if you've got a grassroots group to understand the basic campaign finance laws. Okay, don't take a contribution more than X. Let's say you're a candidate running a long shot campaign for Congress, but you're going to give it your try, right? Okay, don't take more than $2,600, check. Can't take corporate contributions, check. Pretty easy to understand, pretty easy to do. Filling out the disclosure forms, that's the problem. That's the bear. That's where they get caught. That's where they can't do it. One study that was done gave a number of people, 40 people, the disclosure form, standard disclosure form, said, we want you to fill these out. And you got a reward if you did it correctly. So you had an incentive to do it right. You got a cash reward if you did it correctly. It's pretty much, it was $50 or $100 or something like that. Not a single person in the group was able to do it correctly. It's a very complex, difficult thing. It goes on and on. You can't, even under federal law, dissolve as a political committee without getting the federal government's permission. So you've got that kind of issue. I think we also should look at the idea that you can get information from the press. You know, as Tara said, people don't look at their disclosure reports. The press gives them to them. Well, you don't really need to know who funds Crossroads. The press can tell you. It doesn't take a lot of digging, frankly. Again, they knew all kinds of stuff about Crossroads and almost all of these groups. But the question is, should some people be able, if they're so inclined, to wish to keep their actions a bit more private? We have other ways that you can address the potential problems. For example, in jurisprudence, there's something known as the least restricted means. The court should use if you're infringing on First Amendment rights, and you are here, you have to justify it with a compelling government interest, which we have, the informational interest, and you have to use the least restricted means to get there. But we don't use the least restricted means. I mean, we could require that you have to disclose your donors only if you're asking for or get an earmark. Get an earmark? Right, that disclose who all your donors were. Then we could see the trade. We could have more sealed bidding, right, rather than in competitive sealed bidding to get at elements. So there are other things that I think that we could do that would address it, that would not say to essentially all Americans, you know, because some of you are corrupt, all of you have to give up some of your First Amendment rights. I think we can restrict that in a much better fashion. I think that overall, you know, when I think about these reports in the paper, I think one of the things that deadens and dulls American political discourse are these reports. You ever read these reports? Anybody really read these articles? Federal Election Commission today released third quarter fundraising results in the congressional race. You know, so-and-so raised X amount, so-and-so raised X amount. Pretty soon you're like, your mind's numb, and you haven't learned a damn thing about the race, and nobody's talking about the issues, and nobody cares. And we're telling everybody, you know, the issues don't really matter. It's all just money. That's a real harm, I think. I think that's a mistake. I think it tells voters that they can't do anything, and I think it fails to inform voters. It's much easier to learn who gave money to somebody than to actually find out what the candidate thinks or wants to do. So these are the kind of little nagging harms all around the side of things before we even get into some of the more aggressive personal harms that can fall on particular people when they're targeted for retaliation by their government or by others in the private sector.
Well, let's look into some of these consequences that you have suggested. In fact, Brad, you've written about some clear examples where you argue someone has been hurt because of his or her contribution, that it's been disclosed. For example, you wrote about a Republican donor, Sam Fox, whose nomination to be ambassador to Belgium was derailed in the U.S. Senate because of contributions that he made to Swift Boat veterans in 2004. So why isn't that the price of playing politics? If you can play at the big leagues, shouldn't there be a price?
Well, I mean, the Sam Fox is an interesting case, but I'll just try to make this point out. It shows that there are folks in Congress, in government, who will try to retaliate against you for your political activity. In this particular case, John Kerry was really mad because Sam Fox had given money to Swift Boat Veterans for Truth. He was just really mad about that. And he was very open. This man is not going to be ambassador, not because he's unqualified or anything else, because he gave money to Swift Boat Veterans for Truth, my political opponents, right? Now, we might say that if you're nominated for an ambassador, maybe you should have a higher level of scrutiny. We require office holders to file financial disclosure reports. You know, one of the things earlier today, somebody said, does the public have a right to see your tax returns? And we all said, well, I'm kind of uncomfortable with that, right? But we might want to see tax returns of office holders. Why? The purpose of disclosure is for us, the citizenry, to monitor our government. But it's not for our government to monitor us. Right? Now, sometimes those two can't be separated out. If we know that I gave money to a candidate and it's public information, then we know that the candidate got money from me. You know, I mean, it works, it's back and forth. So the question of Sam Fox really just shows that there is retaliation there in government, and that, you know, people will base their decisions in government on something other than what we think about as good government. Well, that's nothing new. That's what Tara's been saying all along. The question is, are we going to get further with added disclosure than we already have or not? A guy applying for ambassador, maybe we should know more about it, but there are lots of people who don't apply for ambassador and also can face that kind of retaliation or threat.
Well, let's follow up on that, Tara. From a different perspective. What's wrong with that argument? Because another thing that Brad has written about is contributions by much smaller players and the results of the disclosure. One of the examples that he has cited is Gigi Brienza. I'm probably not saying her name correctly, but an employee of Bristol Myers Squibb who was targeted by an animal rights group that was trying to shut down a lab that tested drugs on animals. She actually had no affiliation with the lab, but she still had to deal with her name and address being publicized. She'd only donated $500 to John Edwards. So she wasn't a big player, and why should she be forced to pay, in essence, to participate in politics?
Harassment. That is the counter-argument that we hear constantly these days. And I have 2 points I want to raise. One, that there is a legal remedy, and two, I will actually make a concession to Professor Smith's side. So first, in terms of the legal remedy, well, yes, of course there's the possibility that a donor to particularly an unpopular group, a historically disadvantaged group, a minor in, let's say, some party may be targeted for some harassment. But the Supreme Court has already taken that into account when it upheld all these disclosure laws that we've been talking about. And there is something called in shorthand, the socialist worker exception. And the court said that if a group could show evidence that there's a reasonable probability that compelled disclosure of its contributors will subject them to threats, harassment, or reprisals from either the government or private parties, then they could be exempted from disclosure. And it's called the socialist worker exception because it's a fairly stiff standard, and really, as far as I know, the main exceptions that have been granted have been to the Socialist Worker Party and to the Communist Party. They are exempt from having to disclose their contributors. And the Legal Center, or probably most reform groups, do not oppose that yes, they have been subject to a lot of harassment, not just privately, but by the government as well. And that particularly when you're talking about a very unpopular group, historically, unpopular, that we don't want to snuff out that speech altogether through disclosure. But so we would say, well, look, yes, harassment's a problem, and we have a remedy, or we have at least, some way out for these type of groups. And then my concession is that, yes, harassment is raised all the time, and you can probably tell already that I think it's somewhat illusory most of the time. But there is probably something to be said for playing with the thresholds for disclosure. At what point do you have to disclose someone's identity if they're a donor? And at what point does a group even have to fall into a disclosure system? If you're really, truly talking about a mom and pop group that is spending $800 on a ballot measure initiative, then maybe it's not that helpful to the voters to know that Mom and Pop Inc. is actually against this bond or what have you. So I think there are probably ways to raise and lower the disclosure threshold such that really small donors don't get caught up. And many of the examples that you hear in the media are of these like $200 donors where, one would have to think, how do you really get very much information? And how much corruption can they really cause? So I think that might be a point of agreement in the reform community and the speech community that there's probably a way to intelligently set thresholds such that everyone is comfortable with the idea that this much money really might be able to buy you some influence, or at least be helpful in terms of knowing this size donors to a campaign in order to know what the bias, interests, etc. of these campaigns are. But I do have a caveat to that concession, and that is that very, very, so often we're seeing these small donors being used as affronts for very, very, very influential donors. And one example is the Chamber of Commerce, who have been repeatedly talking about the harassment of the Chamber of Commerce. And as a reason not to pass the Disclose Act and other federal disclosure laws to remedy the sort of post-Citizens United disclosure gap. And this is exactly what we fear, that if we if we acknowledge harassment, which of course we do, then suddenly massive billion-dollar groups and billion-dollar corporations are going to claim that they too are harassed, meaning that, what do they mean? They mean that people don't like their politics, that people disagree with their politics, that people might even boycott their stores. But all of this is not harassment in our eyes. This is simply protected speech or honest political disagreement. So while I think that there's ways to design campaign finance laws to minimize harassment, I'm very concerned about, again, this the wolf in sheep's clothing, where small donors are being used to basically hide huge influential donors that really have no reasonable fear of harassment.
So just a reminder that we do want to take some questions from the audience, and maybe Tara, you can over here, a couple over there. So While they're getting the microphone over there, let's turn to a different topic. We'll try to move along a little bit here. Let's turn to super PACs. These big committees that have developed, particularly since Citizens, is there, Brad, some level of anonymity that you think they should have? How much disclosure should we have with these groups?
Well, here's an area where there's a lot of confusion. Super PACs disclose all of their donors. So they actually have full disclosure, the full regime. They're just like any other PAC, except for they can take money in unlimited amounts, and they can take it from any source, not just from individuals. Now, there is the point at which, if a group, if I give money to pay dues to a trade group, and the trade group gives money to a super PAC, right? The super PAC will disclose the trade group is giving it the money, and it won't disclose me as giving it the money. And if you really want to know that, I suppose that would be an issue. As I pointed out earlier, we find out when we really look that amounts to about 4% of spending nationally. And it creates certain problems to try to go much further than that, because you have what you kind of call what you might call the Russian nesting doll problem, right? I mean, this is a very real scenario. Campaign finance attorneys do this all the time for people who have no desire to do anything nefarious. That is, the Acme Widget Company pays its $1 million in dues to the Widget Manufacturing Association. The Widget Manufacturing Association pays its $800,000 dues to the U.S. Chamber of Commerce, or to keep it a hypothetical more, we'll just call it the business chamber, right? The business chamber likes to work with state chambers business, and so to promote that, they tell state chambers, if you raise some money for races in your state, we'll match it. So the state business chamber raises $600,000 from 50 or 60 companies, donors, right? And they get $600,000 from the U.S. Chamber of Business. Then the state business chamber has all this money now, but they decide rather than spending it themselves, they're going to give it to the State Business Alliance, which is a coalition of the retailers, the wholesalers, the manufacturers, and the business chamber. And then that group spends the money. Now, Acme made its contribution, let's say, in December of 2014, shortly after the election. The money is spent on ads in October of 2016. What should be disclosed? And this is passed through the system. How far up are you going to go? How much are you helping people understand what's going on if you say, well, this is really Acme money? It's not really Acme money. I don't think you could say that in any meaningful way. I don't think you can say in any meaningful way it's Widget Manufacturers Association money, right? So you've got this kind of problem. And you can say, well, we want to go back 3 levels or 2 levels or within a certain time period. Whatever you want to do, then if I am the clever lawyer who wants to be more nefarious, believe me, I'll work around it. I'll just make sure the contributions are made on the right time frame. I'll stick more groups in between, whatever you want to do. You can have situations where it's actually misleading, because most of us are members of groups, and I don't know anybody who's a member of a group and agrees with absolutely everything the group does, right? So sometimes groups do things you don't like. So let's say I give a bunch of money to the Republican Party or to the National Rifle Association. I said that's the best way to elect Republicans, right? They really get the vote out. Okay, well, the National Rifle Association has a policy of endorsing incumbent Democrats who have a pro-gun record. So then they endorse the incumbent Democratic governor of my state who's got a pro-gun record. This would be a very real possibility. You think of Bob Perry giving money to the NRA and them endorsing Ted Strickland running for re-election as governor of Ohio in 2010, right? Is it really true that Bob Perry is endorsing Ted Strickland? Bob Perry, uber Republican? No, of course it's not true. It's not true at all, and it doesn't inform voters to have that information put out there. So super PACs do disclose. One could argue that we want to know more than we're getting, but note that we're getting quite a bit, right? And to get more is going to require, again, chipping away at the confidentiality that some people might prefer or want and have good reasons for, and it's going to be very hard to do. We run into what we call junk disclosure, where people are getting stuff that's actually misleading rather than enlightening.
So before we get to the question, Tara, take a shot at that. Follow that. That can be a somewhat circuitous route when you try to follow the money with these PACs. And so what information should they be required to disclose, and what would be of practical use to a voter?
Yeah, well, I agree with Professor Smith that first, super PACs are not really a problem. They are federally registered political committees, and they basically have to disclose everything, everything that comes in and everything that comes out. When I use my shadowy group language, I'm actually talking about certain tax-exempt nonprofit groups that are organized under Section 501c of the tax code. This sounds all very complicated, but you may have heard various news reports of all these 501c4s or 501c6s. And these are the groups that don't disclose anything. Because, as I mentioned earlier, tax law is just really not designed for this. And campaign finance law has been weakened to the point that unless a donor says, please use my money for a hit ad, then that group doesn't have to disclose. So that's really where the problem is. And there is this Russian doll problem that one, Americans for America will give to Americans for Reform, which will give to Americans for Prosperity, which will give to Americans for Apple Pie, and that it's hard to trace the money. But I don't think that's a reason not to have disclosure. Because people are trying to keep their spending secret, there's probably a reason to shine a light on it as opposed to just turning your back, because one would think that the people who are routing huge contributions to the systems are the ones exactly who want to influence the election or who want to get a payback and have no one know about it. So I would say it's the opposite, that the bigger the Russian doll problem, the more you might want to investigate it. And finally, it's not that it's 100% solvable, but there are solutions. The Disclose Act had a fairly simple solution. They said any time a group takes money, they have to create a segregated account if they want to spend it on elections. So, you can take whatever money you want to take. You can put it in a general fund or you can put it in a segregated fund. If you put it in the segregated fund, it gets disclosed. So you have an interest in always putting it in the segregated fund, or else you have to disclose everyone. So, if you create an interest for all these groups to keep their election money separate and disclosed, then perhaps they will do it. This won't necessarily get rid of all schemes, but there's definitely ways to design the law to greatly ameliorate the Russian doll problem or people who are deliberately keeping their money secret, and in ways that sort of protect the sort of more innocuous sort of chambers or unions that may actually have many affiliates. So I don't think that defeatism is really the answer to people trying to game the system. I think concentrating on it and designing laws is the way we should respond.
And maybe sometimes the media confuses things by using super PAC as a term of art that
absolutely
doesn't cover.
We deal with that probably every week.
So let's go to the question back here.
I'll apologize in advance for my complete lack of campaign finance law and knowledge, and I may be asking something that Supreme Court doctrine just doesn't permit this distinction. But I'm wondering, in the balancing you all talk about, if it makes a difference whether the donor we're talking about is an individual person as opposed to a corporation. It seems to me that most of the benefits that Ms. Malloy is identifying are most applicable when you have a corporate actor. And Mr. Smith, or Professor Smith, excuse me, most of the examples you give of kind of afraid of horribles in the context of privacy and harassment are individuals. And at least when I think about it in my head, if I think about costs and benefits, if I'm talking about knowing who John Q. Public gave his individual donation to, I think the public good of that disclosure is perhaps not that great. I think the privacy concerns are higher where he's an individual, but I think my concerns about First Amendment rights are higher. Whereas if it's a corporation, and I know part of the reason I don't really care who John Q. Public gives his money to is because I assume even if I disagree with him, he's an individual making his choice based on what he believes to be in the interest of the public good. Corporation, on the other hand, by law, is making its decisions based on its bottom line and its profit. And I do think the arguments for the benefits of disclosure are certainly higher, and I really don't care about privacy with respect to corporations, and I really don't care about First Amendment rights with respect to corporations. And I understand the Supreme Court doctrine may not permit this distinction, but I was wondering do you think it should make a difference when we talk about balancing to suss out individuals versus corporations?
So would you like to say that?
Sure. No, I think you raise a number of good points. One of the things, again, I want to stress is that in this debate, the aggressor, for lack of a better term, is and she doesn't seem like an aggressor, but it's terrible. It's her side that's saying we need new laws, more disclosure. Is by and large not anybody saying we need to roll back disclosure, and particularly on certain things. Our effort to roll back disclosure is primarily something which I'm very pleased that we've kind of won on, because I don't know the first person to say it. It was just 15 years ago, you wouldn't have found a person in Tara's position saying, yeah, maybe we should raise the limits. It was every penny instantly on the internet. And now we've kind of come around to recognizing, we really don't need to know every penny. We don't need to know it instantly, which kind of goes to your concern. Small donors, individuals, we don't necessarily need to know. I do think that there is a difference there. But note that the legislation they now favor to get at this 4%, right, is legislation that would require, as she said, trade associations and nonprofits to disclose who their donors are, okay? Now, some of those donors to trade associations, especially to trade associations and the nonprofits, are corporations, big corporations. Some are very small corporations, and some are individuals. In other words, the NAACP case, for example, where the court held that you could not require a group to divulge all of its members as a general matter, or to divulge all of its funders, was aimed at protecting the individuals who were members of the group. And that's what the reform community now wants to get. They want to get exactly what you've kind of said. I don't think that's what we need. Now, they also want to get the big corporations. There's no doubt about that. And it might be that we could do a better job of figuring out a way to tease the two apart. Right? I think that there might be something that could be done in that way. But that's not what's being proposed. It's not what was in the Disclose Act. It's not what I've seen in various state laws. And so until we kind of get some willingness to back off almost, I feel like we can't really get into that debate of saying, you know, is there something you want to do that's worthwhile? And I want to point out one thing. Tara made the point, and she's quite correct in this. She said, well, you have a right to boycott people. You have a right to explain that you don't like them and so on, right? Absolutely. I would not disagree with that, okay? But where is the significant government interest in giving people, enforcing people to provide information to their political enemies so that their political enemies can harass and boycott them? Right? Just because I have a right to do something doesn't mean that government has an interest in intruding on your right to enable me to harass you, right? We remember we've got to start, what is the compelling government interest in forcing you to divulge information that you would prefer not to divulge? And I submit to you that it is not a compelling government interest that some people will want to harass you if you do that. In fact, to me, that's exactly the problem. Too often people are not looking for the disclosure information because they want that voting cue that Tara mentioned correctly. Say, well, gee, I know if this group supports this, I'm in favor or I'm against or something. They want it because they're going out there and saying, I know what I think about this speech, and I hate it. And I want to harass the person who's putting it out there and make them stop. And I suggest to you that is a very undemocratic approach. It's not the approach we want to foster, and there is no significant government interest at all, not even a minor government interest in assisting that behavior, even though it might ultimately be legal.
So Tara, the question, individuals versus corporations.
Yeah. Well, I think that in many cases, there probably is a greater interest in learning corporate support or, let's say, nonprofit corporate support for a candidate or ballot measure, simply because we might have more background on what that group stands for or what their financial interests are. I do think that, as you hinted, that the Supreme Court might not allow that type of distinction following Citizens United, because the whole basis of the Citizens United decision, or one of the bases, was that you can't distinguish between corporations and individuals for the purposes of their First Amendment rights. Now, clearly, I disagree with that, and many do, but that seems to be the law of the land. One of the interesting areas where there is some question about that, though, is this socialist worker exception that I mentioned earlier, and that Brad alluded to in mentioning the NAACP case. That this exception seems, not explicitly, but sort of impliedly to relate to physical violence or personal harassment, and that it seems to sort of imply that we're talking about an individual as opposed to a group or corporation. And in fact, there was a DC Circuit case dealing with lobbying disclosure. It was a National Association of Manufacturers did not want to disclose their corporate donors. And there the court sort of poo-pooed the harassment claim there, because they said, it's never really been said, but this harassment claim really seems to relate a lot better to individuals than to corporations. So that is sort of out there, but I don't know how that circuit court holding is really going to go up against Citizens United if indeed there was an attempt to really distinguish between corporations and individuals. And finally, I would just point out that it's true that maybe the informational interest is less in individuals, but the anti-corruption interest is still possibly quite strong when you're talking about individuals, when you're talking at least large donations. And in some ways, those are the ones that go under the radar during the election, but that 4 years later or 3 years later or a government contract later might become very, very salient. And so I certainly don't think that simply because Joe Schmo is not particularly informative at the time of election, that it might never be, given the anti-corruption interest in connecting the dots between quid pro quos. And finally, one last point. Yes, there is probably harassment that goes on of individual donors, but I would point out that we've had very strong disclosure laws for candidates and parties for now 40 years. There are probably half the states that have ballot measure disclosure laws. There are millions and millions and hundreds of millions, billions maybe altogether in the last 40 years of people who've been disclosed under these laws. And we have a handful of examples of harassment. So while I don't want to completely downplay it or pretend it doesn't exist, I do think we have to take this into measure too if we're doing a cost benefit, and the costs at least spread out over 40 years and a country the size of America have actually been fairly small in terms of harassment.
I gotta make 3 quick points. I will try to make quick.
We'll make them quick. So we get one more question.
One is I agree with Tara that I think the harassment can be overdone. I do think we need to recognize, though, that a lot of it doesn't have to rise to a level of strong harassment before we might want to reconsider it. For example, many candidates, challengers normally, complain that they have a difficult time raising funds precisely because the donors will be disclosed, and those donors know that this candidate's a relative long shot to beat the incumbent, and they don't want to risk retaliation by that incumbent. Now, sometimes that's just an excuse for their own poor fundraising, but I think there's a lot of truth to it. I know people who contribute $199 precisely so they stay below the mandatory disclosure threshold for business reasons or other. A second point, this is just kind of fun. I've always kind of chuckled at the socialist workers exemption. While I agree with it, it seems kind of odd that one group that doesn't have to disclose its members and supporters is a group that openly calls for the overthrow of the U.S. government. But if you're just ordinary citizens wanting good government, then you've got to disclose all this and subject yourself to this kind of various harassment of certain points. And I had a third point, but I don't remember, so let's go on.
All right. So last question. There we go.
Hi. Thank you guys very much for coming today. The example you gave earlier about not Ambassador Mr. Fox, it seems like small beer when you think about it. He tried to mask his involvement in a certain activity, political activity. It was unveiled. He lost out on a plum perk that's given typically to wealthy donors or political endorsers. That's not what many people are afraid of. They're not afraid of one rich person losing out on one very nice title. They're afraid of bigger corruption. They're afraid that Mr. Fox's goal wouldn't be an ambassadorship, but it might be a pipeline from the tar sands pipeline or an electric car investment from the federal government. I'm curious, Professor Smith, why aren't you afraid of those things?
Okay, first, I agree with you. That's why I don't like talking that much about Sam Fox. I think the relevance of Sam Fox is only that it's a case that shows that members of Congress are interested in retaliating against their political opponents and will do so sometimes when they have the chance. And that's just one example. I haven't talked about Sam Fox in years. I don't remember ever writing about Sam Fox, but I must have because I know Ross found it and brought it up, okay? So I agree with you there. As to the issue of corruption, I mean, look, to a large extent, I agree with you there too. These things can be problematic, but we shouldn't overstate these things. Again, remember, we're talking 4%, right? We're not really talking that much. And we've got to start saying, what trade-offs do we want to make in life? Now the real question is not, in my mind, it's who is realistic here. Anybody who works can tell you, anybody who's an economist for sure, which may be not much of an endorsement, but will tell you, you can't get rid of everything. You can't stamp out all crime. If you do, you're going to have a police state, right? You can't stamp out all pollution. If you do, you're going to be living in poverty and dying from lack of clean water and food and medical care, okay? You can't get rid of anything perfectly in society, and you can't get rid of all corruption in government. There are corrupt people out there, right? And there are corrupt people elected to office. And we find them now and then, and they're booted out of office. They're not found because of disclosure laws, by the way. Those never really helped. And that's not really what the problem is, right? And you can't, so you have to take a case of realistic balancing. And I think when you start with the provision that we have more disclosure now than we've ever had in history, and right now there's this desire, we're just freaking out because we got 4%, and we know who paid it, we just don't know who gave money to the people who paid it. Is that really where you want to go? Because you're intruding, you're putting at risk NAACP versus Alabama, you're putting at risk all the other cases that support that, Talley versus California, and Button, and Bates, and and several others. Thomas v. Collins, which deals with the ability of union organizers to operate anonymously without having to disclose who they are. Okay? You're putting all of those line of cases at risk. The vast majority of them dealing with civil rights of one form or another, not always race, but like I say, like union organizers and so on. And you're doing this for what? What proof is there? What evidence really is there that you're going to get what you think you're going to get? Right? That we're going to suddenly uncover this and stop this added little corruption. The era of McCain-Feingold is the era of William Jefferson with $50,000 in cash in his office fridge in Congress. It's the era of Bob Ney. It's the era of Jack Abramoff, who's out now stumping for campaign finance regulation. Yes, we got to have more disclosure. He's out there doing this, right? The corrupt people hiding behind this. And so that's my basic message today, right? Again, there is not, to my knowledge, a single bill in Congress that would roll back any disclosure law, period. There's not even a bill to slightly raise the thresholds to $1,000 before you have to report. Something even Tara has said, she might agree with, maybe 600, 800. There's not even one of those, right? What we have is an effort to force people under government compulsion to reveal their political activity for the primary purpose, I submit to you, so that their political adversaries can harass them. And we should note that prior to Citizens United, we go back to 2002, NAACP is running ads showing reenacting the death of James Byrd, dragged to death behind a pickup truck, black man lynched by a bunch of white racists, right? They're running ads the week before the election, and James Byrd's daughter gets on and says, when George Bush once signed hate crime laws, it was like my father was killed again. And you know what? We didn't know who gave the NAACP that money. We don't know. We knew the NAACP paid for the ads, but we didn't know who gave them that money. And nobody cared. The Brennan Center wasn't business. They weren't going, oh, this is terrible. They didn't say a word about it. And many years ago, maybe things change. Maybe attitudes, as Tara suggested, toward disclosure do change. Some people want more than they used to care about. But I suggest to you the reason they didn't care then is that they liked the NAACP and they don't like the people they think are going to speak under Citizens United, so they want to get them and they want to tell them to shut up. Or as Chuck Schumer said, the deterrent effect should not be underestimated. And that's what we're talking about today. And you should not presume, if you think this is a great idea, that you're always going to be the one who's deciding who needs to be deterred and who doesn't. Thank you.
So we need to wrap up. Tara, did you want to take a chance at a basic,
yes.
underlining your basic message?
I actually, despite it all, want to go back to Sam Fox. Because really, this is an example that I think does not support that side, but supports my side. You say, oh, Sam Fox has gotten retaliation. I say, why the heck was Sam Fox up for the ambassadorship of Belgium? He was not a Foreign Service officer. He didn't have any background in foreign policy. As far as I know, he had no connection to Belgium. I think that was a country. He was given it as a reward, and this is very typical. It's not just Bush. I think there's been comparisons of Obama and Bush, and the same plum assignments go to the same big contributors. And in fact, it's almost normal, and I would suggest that shouldn't be normal, and that type of quid pro quo should absolutely be, if not forbidden, at least should be voted against. So I think we have, first of all, a very, very different impression of what corruption is or what we need to solve. Brad says that disclosure is not going to do anything. Well, that's easy to say if we don't have any disclosure because we don't actually know what we're not seeing that is possibly corrupting government. So why don't we get to a point of transparency first, and then maybe we'll decide whether or not there's any problems in government. Not knowing everything is a great way not to know if there's a problem at all. But I would say, yes, disclosure is not the be-all, end-all, and we would like a lot more in terms of regulation, things that have been struck down by the Supreme Court and Citizens United, the corporate spending restriction, public financing. We're certainly not disclosure over everything, and clearly there's going to have to be a much more broad-based solution to not only the corruption problem or the voter information problem, but also the problem that the group of people financing our elections is minuscule. Throughout the last decades, we're talking about people who even give more than $200 are only 0.5% of the entire American population. We're talking about a tiny group of donors, and when we're talking about the type of Sam Foxes that actually give real money, we're talking about probably 10,000 people. So I mean, these are very small. This is a very small group of donors, and part of the problem is that everyone feels divested of government because they think it's controlled by these small groups, and that is probably not inaccurate. So I think part of the problem is not just corruption, it's not just public information, it's not just disclosure, it's about empowering everyone to think that they actually own their government. And that's going to take a very broad-based solution, of which disclosure is a key but not exclusive component.
The advantage of being a moderator or a reporter is that I don't have to footnote my sources, but I'll go back and look that up.
I'm sure I wrote it down. I don't disagree with Tara. I don't think it's a particularly good case that means anything. And when we're debating over something we agree on, I think that suggests that we're not hitting the real issue.
Well, we've run out of time. I want to thank Tara Malloy, Senior Counsel of the Campaign Legal Center, and Bradley Smith, Chairman of the Center for Competitive Politics. Thank you.